And the debate over your gun rights feels like 1939. That's the last time the Supreme Court addressed the constitutional right to bear arms.
It might be hard to believe, but not once in the history of this republic has the court ever said what the Second Amendment means.
Oh, nice to see you, my friend. How are you, Stephen?
Woo! Happy Gun Day, John!
Both sides of the gun control issue were on display as the U.S. Supreme Court takes up a landmark Second Amendment legal battle over the right to keep and bear arms. The case before the High Court is the District of Columbia versus Heller.
To agree that owning a gun is an individual right.
The amendment says we reaffirm the right to have a militia. We've established it. But in addition, there is a right to bear arms.
The Supreme Court will hopefully tell us the Constitution does not end at the borders of the District of Columbia. The citizens of Washington, D.C. enjoy all of the constitutional rights that every citizen enjoys.
Jessica Guadalupe reporting from Washington, D.C. from WBMW. We're about to hear the courtroom's decision regarding the District of Columbia versus Heller case.
Hi, my name is Michael Lafino reporting from CNN. I'm standing right outside the Supreme Court as the Supreme Justices are about to reveal their decision on District of Columbia versus Heller case. I want to gather a few people and ask them a few questions. Excuse me, young lady. Get off the phone, and what do you think the Supreme Justices will rule in District of Columbia versus Heller case? Do you think guns should be allowed or they should not be allowed in the United States?
I'm a huge advocate for less gun control, and I think they should allow it.
Why would you think they should allow guns? What do you think that will do for our country?
Well, in general, especially in Washington, D.C., where there's complete restriction against gun control, the innocent people that need guns aren't allowed to get any, whereas the criminals, when they want to, they can get it, so it leaves us defenseless.
So do you believe that if every citizen of the United States was able to have a gun at home, we would live in a safer place? This is not a funny matter.
I believe so. The reason I believe it is because I feel that there are more good people in the world than there are bad, so people will help each other.
Thank you so much for your time. What was your name?
Ben.
Okay, who cares? Still standing here outside the Supreme Court. In about half an hour, the justices will reveal their final ruling on District of Columbia versus Heller case. And before they do, I just want to ask a few more people what they have to say about this case. I'm sorry, ma'am. What's your name?
Lily.
We're standing outside the Supreme Court waiting for the justices to reveal their decision on District of Columbia versus Heller case. What is your opinion on this matter? How do you think they should rule?
I am definitely for gun control. It's time to put this to an end. Washington, D.C. has seen enough of killings and suicides. The only way to stop this is we need a law banning all guns.
So you mean if there are no more guns means no more crime. Is that your opinion on the matter?
Yes.
Thank you so much for your time. Now that we heard two mainstream opinions, we're going to go inside the courtroom where in just several moments the judges will reveal their ruling.
Everyone please rise. The court is now in session.
Everyone may be seated. The D.C. versus Heller has been a trying case. It is about restriction on handguns. Anthony Heller wants to keep a gun in his house. Heller argues that it's his Second Amendment right to have a gun for his self-defense. After much contemplation, we have reached a verdict. I hand down the decision to Justice Ruth Ginsburg.
When the Heller case was first brought to the district court, it was dismissed. And then it was filed to the U.S. Court of Appeals for the D.C. Circuit, which overruled it with a 2-1 decision. We unanimously uphold this decision. Gun control was made in effect to protect the people, but when it ceases to do its goal, the law must be changed. We have overlooked the lower court's decisions and found Henderson's dissent inconclusive. The disparity between the District of Columbia being a state is a matter of semantics. Neither life nor sense of security should be lost over words. The District of Columbia was never intended to encompass such a population, but we cannot today say that no one lived there. The Constitution is a living, breathing document, and we must live and breathe with it. Americans need never fear their governments because of the advantage of being armed, which the Americans possess over the people of almost every other nation. Statistics and facts have played a major role in the decision, as have the amicus curiae brief. In our research with the National Crime Victimization Survey researched in 2005, we have found that 477,040 victims of violent crime stated that they were faced an offender with a firearm. Further, and the FBI's crime with firearms estimated that 66% of the 16,137 murders in 2004 were committed with firearms. Stricter gun control has not done its duty, and to keep a law for the sake of keeping a law is unconscionable.
As my colleagues have just mentioned, the court concludes that the Second Amendment protects an individual right to keep and bear arms. The Bill of Rights is about individual freedom, not prohibitions. It was created to satisfy the needs of the anti-federalists, the very people who fought in defense of individual and states' rights. If the solution to the lack of individual rights under federal government was the creation of the Bill of Rights, then it becomes obvious that each right guaranteed by the Bill of Rights becomes an individual right. If we are to consider the Second Amendment as guaranteeing a collective right, then we might as well consider all the other rights listed in the Constitution as collective as well. The people is a very distinct term in the Constitution from the states. The people refers to individuals, not larger entities. No one would argue that the right of the people to petition the government for redress of grievances applies to state officials, but not to individuals acting on their own accord. Similarly, the rights to general free speech, religion, etc. are not rights of state governments against the federal government, but rights of the people against the nation. Therefore, Dick Heller, like any other individual, has a Second Amendment right, an individual personal right, to have a gun in his home for self-defense.
Looking at previous cases and regulations, such as Bliss versus Commonwealth, it was ruled that citizens most definitely have the right to bear arms in defense of themselves or the state. Any legislative act which takes away the privilege or diminishes would also be void. Finally, the case also ruled that the act to prevent people from carrying concealed arms are unconstitutional. Also during this area, the case State versus Berard arose. The state of Arkansas adopted a viewpoint that many argues for and against in contemporary times. The Second Amendment is not a right for the individual or a collective body. It is a military political right. They read a close interpretation of the article, especially of the words "a well-regulated militia" being necessary for the security of a free state and common defense. Those two cases form the basis of an issue present today and are only two of many conflicts which arise due to many interpretations of the Second Amendment. In the 1920s, during the Prohibition era, there was a mass murder because of the usage of submachine guns. President Roosevelt ordered the formation of National Firearms Act of 1934, which ordered that in states where automatic guns are not prohibited, the owner of those guns pay a $200 tax, send a copy of the fingerprints in, obtain a certificate with official approval, and approved by the BATF. $200 was approximately $2,525 nowadays. And the process gun holders go through to obtain a gun is a tedious task. If we are not completely banning guns but are making more and more restrictions, what is the point? Slowly, we are losing our individual right.
One of the factors we must consider is the historical context of the Second Amendment. As Thomas Jefferson said, on every question of construction, carrying ourselves back to the time when the Constitution was adopted and conform to the probable one in which it was passed. And when our founding fathers wrote the Second Amendment, their intention was for the Second Amendment to be an individual right, a right for the people to bear arms. The militia clause was not proposed to restrict the right to keep arms to only the militia affiliates. Borrowing the words of George Tucker, the right of self-defense is the first law of nature. Alexander Hamilton and James Madison also agree that the Second Amendment is an individual right. In the Federalist Paper, number 28 and 29, Hamilton agreed that the people should be allowed to carry guns for their protection. It is our birthright, and the federal and the state government cannot take that right away from us. They have no power to disarm the people. According to our founding fathers, the Second Amendment is not a militia right and not a collective right, but an individual right. The authority belongs to the people.